And Eamon is a professor at UT teaching professional responsibility, among other things. And I don't know if you know this, but coming up next month's State Bar Journal will have the proposed disciplinary rules for your perusal. So Chuck and Eamon are going to have to just basically touch the high points, but please go through the State Bar Journal and look at the proposed rules before you vote on them. I understand the last time I heard is either late January or early February for the for the referendum. Do you know anything different?
January 18th and February 7th.
Okay, January 18th is when the referendum for these new disciplinary rules, you'll be getting an email from the State Bar, and you'll be voting on them, and it will conclude in February. And these are important things here today. All right, without further ado, I'm going to go ahead and turn this over to Chuck Herring and Eamon Burton.
Thank you. Our topic is the proposed disciplinary rules, and I'll start with the rule background. Like I said, this is very important because these rules are going to affect a lot of your practice, from case acceptance, who you can take as clients, to your contract forms, to your billing, to conflicts of interest, disqualification, and on and on. So they are important. Let me spend just a minute talking about the background and how we got here, and then Eamon was on the State Bar Committee for a while. I'll let him talk a little bit about that and sort of his overview. But the background really started in 2002 when the ABA amended the model rules. And as you know, the ABA has model rules of professional conduct, and most states tailor their rules either closer or farther away from the model rules. The Supreme Court, the next year, 2003, appointed a task force. The task force issued a report in 2004. The State Bar Rules Committee was not pleased with some of the recommendations, and hence we've had several years of discussions and back and forth since then. The Supreme Court took all that in October of last year and issued some proposed rules. They've got hundreds of comments and objections to the proposals, then issued a new set of proposed rules in April with comments issued in July. And they told the Supreme Court, they told the State Bar to comment on those. The proposals have 5 entirely new rules and a new definitional rule that will affect all of us. The State Bar was supposed to comment on October 6th and did on October 1st. And what happened was the State Bar Board said, well, we don't think we're prepared to comment on the conflicts rule. It's probably the most important, controversial group of rules and proposals. And so they asked until next spring, really. They asked to make a recommendation next month in January and have a referendum in the spring, and the Supreme Court said no. That's too long, so we want quicker action. The Supreme Court gave a deadline of November 8th, and the Bar made its recommendations. On November 16th, the Supreme Court issued its miscellaneous order that has finalized the recommendation, the proposed rules that you'll vote on. And the Supreme Court rejected some of the Bar's recommendations and accepted some. Voting starts on January 18th. January 18th, you start voting, runs about a month to February 17th. We vote on the rules. We do not vote on the comments, even though most do need to read the comments. The whole thing runs 164 pages, 65,000 words. You can read it in just a matter of hours or days, really. But you don't get to vote on the comments at all, even though that's 2/3 of what's going to affect us. There's been discussion about the cost of this. If you read it 4.3 hours, average reading speed, it times 88,000 words. It's a lot of money just to read the things, and then to implement them, and then to change the disciplinary system. A lot of cost associated with it. Let me stop there. Eamon was involved in part of the drafting process and has some pretty strong opinions about where we are now. Why don't you give your overview thoughts, Eamon?
I think the first thing I want to say, is this on? The first thing I want to say is that the Supreme Court's not involved with some of the problems that we're going to talk about and some of the disagreements we have with these rules, because there were 2 committees that worked on, as Chuck referred to. There was the task force, and then the State Bar Committee said that we'd also like, the Standing Committee on the Texas Disciplinary Rule said we'd like to draft proposed rules as well. So the court said, in my personal opinion, this was a mistake. The court said, well, why don't you come up with the rules yourself, and then we'll look at what you propose, and then we'll look at what the task force came up with, and we'll have two committees with rules, and we'll choose the best of them. Suffice it to say, what happened is the court ended up literally mediating between the two committees. I don't think that appellate rules, ethics rules, any other kinds of rules work very well, or the process doesn't work very well. It ended up mediating between two committees. And so I think the underlying problems that we have here that we deal with is the fact that the process was not done in what I've seen happen with the restatement of law governing lawyers and the ABA rules and some things like that. So be that as it may, I would like to endorse these rules. I can't, because I think there are too many problems in them. First of all, they're Texas-only rules. These are unique rules to Texas. They pick up some of the ABA model rules. Some places they've got the ABA model rules, but they are Texas-only design rules. And the State Bar Committee was that was what they wanted to do. They wanted to draft their own rules. They thought that we could do it better than the ABA. It's hard drafting rules, no matter what type of rules you're drafting, but it's not an easy task. I think this is a perfect example of it. I dissented to the conflict of interest rules because I thought that they were so far from the ABA model rules. They were swimming upstream while the other states are adopting the ABA model rules. Most recently, California, which had its own rules. California had California-only rules, and they were in the final process of adopting what essentially is the ABA model rule. The type of problems that were in the conflict rules that the State Bar Committee came up with, I'll just give you one example. The most common conflict rule that we deal with is the former client rule, that you can't represent a new client against a former client if the two matters are substantially related. And of course, it's defined since the 1980s, the Supreme Court has said, the two matters are substantially related if the facts of the two matters are so related that it creates a risk of violating confidential information. The Texas Bar Committee decided that we ought to just abandon substantially related, and we ought to adopt a substantially benefit standard. And the substantial benefit standard, which did not make it into these rules, I won't spend much time on it, but it's important to get a sense of the perspective of the development of these rules. The substantial benefit rule would, you could hardly think of how in the world would you ever figure out if a new representation would benefit from the information you got from the former representation, unless you had to reveal it to somebody, an agreements committee or an motion to disqualify. And so just from a practical standpoint, it wouldn't work out. And I mean, I couldn't imagine myself trying to explain to a client that, sure, the information I got from you in that prior representation will benefit this new person that I'm representing adversely to you, but it won't substantially benefit the new person. I thought, well, that's going to really give comfort to a client. But those are the types of issues that were involved, and we continue to have problems with substantial related we'll talk about in detail. But basically, that was the point of view that many of these rules were drafted from, is that we ought to have Texas-only rules. They're merely disciplinary standards. They're not standards that have anything to do with civil liability, that have anything to do with motions to disqualify. It's like we've ignored everything that's happened since the mid-'70s, because we've had all the revisions to the ABA rules, and the state of the law governing lawyers, and most importantly, we've had case after case, because malpractice, breach of fiduciary duties cases now they're common now, and it's a part of the law governing lawyers. And these rules expressly point out that this has nothing to do with civil liability. Well, these are the minimum standards of conduct of lawyers, and of course you've got to use something, and they use these rules. And to say they don't apply to civil liability is a certain matter of illusion. But anyway, that's sort of an overview conceptually why I've had some problems with it. Let's get into some specifics and let's talk about what you're going to be voting on.
Yeah, let me first point out the new rules. We have 5 new rules. There we go. Sex with clients, clients with diminished capacity, duties to prospective clients, and then law reform activities affect client interests, and then definitions. The definitions, that's a very important rule. They took the terminology section, the preamble, moved it into a new rule 1.00, and it has new definitions. A lot of actually closer to the ADA definitions, but not all of them, as Eamon will point out. Well, we got to start with sex because ethics guys never get to talk about anything sexy. So here we go. We have sex with clients, a new rule. I've probably given a dozen, 14 talks on the proposed rules over the last year, and this gets more intensity. And that was true in the public hearings the state bar had than almost any other rule. We've been fighting over it for 15 years, 20 years in Texas. Okay, sex with clients. New rule 1.13, an attorney shall not condition representation or the quality of representation on sex with client, nor solicit sex in exchange for fees or expenses. The earlier version of the rule omitted expenses, but they decided, well, he probably shouldn't get sex for expenses. And then here's those are fairly non-controversial perhaps. Here's what has raised so much of a ruckus recently, and it's the provision that says, "Thou shalt not have sex with a client you personally represent, unless you're married to the person or have an ongoing sexual relationship that began before representation." So, if you're in a law firm, can you transfer the representation of the client to somebody else and say, the representation's developed in a different direction than I had anticipated. Why don't you handle the law and I'll handle the sex? Okay? Can you say that? Well, yes, you can with this rule. Here's what the rule effectively ends up providing. It's okay to have sex with your firm's client if you don't personally perform the legal services, if you don't personally oversee the representation, if you don't set the fee. However, you can get paid for the client, your client's work, the fees to the firm. And if you don't charge for exchange of the sex for fees. Some solo practitioners have said, hey, that's no good. That means any law firm with 2 or more lawyers has got an automatic out. That's 66% of lawyers in private practice, and it's only the solo lawyers who are stuck with solo sex. And so that's got a lot of attention. It's also got a lot of attention because there are lawyers who believe that from a libertarian perspective, the bar ought not to get involved, or we ought to be limited to Rule 1.06, the conflict of interest rule. So it's pretty controversial. What about corporations?